Goofy. Try to get the whole slide in there. I guess a little bit of me. Not the whole slide, though. Whole slide. And still not the whole slide. I got Florida constitutional. Now I have constitutional law. Any constitutional law? No, this is perfect as long as I line it up just right. Now I got, okay, I think that's working. Yeah, all right. So everyone's done with all their midterms, I would presume. No, still more midterms to go. What? Okay.
Mediation. That's not really a midterm, it's like a book exam, but it's during midterm week.
Yeah. So, and after that, are there more graded things in your other classes before the final exam? Yeah. I was speaking to a professor, seemed like a nice guy. He works here. You know, apparently that's their shtick now. That's their goal. More graded things. So, I don't know. I went to law school. There was the one grade. It was the final. It was the end of the class. Why was it like that? I don't know. No one asked our input. But maybe the times they are changing. I don't know. So what do you think? Is that better? Is it worse to be graded several times during this law school semester? A love-hate relationship. Okay. Yeah.
I'm used to the more grades.
Yeah, you were used to it. Yeah.
Usually studying all semester, we have to like prepare more requirements as well.
Yeah, it's more balls in the air to juggle. That's true. Yeah. So, yes.
I don't know if it feels like there's anyone else that's just kind of patronizing, because that's how we were graded in college. And in theory, it's like multiple checkpoints for, are you doing well? Did you pay attention? Did you pay attention? Now you got it. Whereas like in theory, we're all supposed to be here, ready on game day. That's the day. You know?
Right.
And I feel like since our previous bar grades weren't high enough, they're not getting it. We have to coddle them and grade them. Not to mention I don't like preparing until very end anyway. But
Yeah.
you know, it just feels like coddling.
Well, yeah, I hear you using the word coddling. I heard you use the word patronizing. Yeah. And anybody else agree with those terms, or some more agreement here? Anybody disagree? Well, I don't know. I'm not a decision maker on these things. So. But yes.
I definitely do think quizzes help, but there's a time and place, and definitely just taking the midterms, that just sucks.
Yeah.
Well, with immigration law, we had a lot of quizzes which helped out, but they were weighted quizzes, so, you messed up, you learn from your mistake here. They put so much weight to the quizzes or your midterms, and you're just like, freak out for no reason.
Huh. So you think there was too little weight on the preliminary graded
I think it
things?
was too much weight.
Too much weight. Well, I hear you. I don't know how the other classes grade, but I would find it discouraging if I was halfway through and I already realized I'm at the bottom of the pack and there's no way up. You want to have a way to cross the finish line in the top of the pack. You don't want to be discouraged 1/3 of the way through or 1/2 of the way through, especially when there's a curve. So I can see that. I can see your point on that. I think I'm just rephrasing your point. I think I see your point. Do I see your point? Okay, I hope I see your point. Yeah.
So touching on those same two things, though, it feels like the school is fixing the educational process with throwing more grades on a book.
Yeah.
It doesn't feel like the goal is to increase bar passage rate, but it feels like they don't want to actually make. I don't know if it's the teachers or students whose fault it is in an area. They don't want to make more work for them. They just want to put more. It feels like they just want more checks on the notebook.
Yeah. I see that sentiment too. Yeah.
Did they ask for your opinion at all?
No. No one asked for my opinion. Volunteered it. I'm not sure they would take the time. Let's do. Who knows? Maybe they would drop everything and change their ways. I have no idea. No one's come knocking, asking me my opinion. Yeah. But for most of you, the midterms are over. Hopefully, you taking a midterm, you see a question and a light bulb goes off, and you know the answer. Hopefully. But have you ever, raise your hand if you have you ever had the opposite experience where you learned that lesson? And how on earth do you forget such a thing? You've been there, you've done that. Happened to me this morning. I wasn't taking a midterm, but I'm bringing Patrick and Madeline, my son and my daughter, over to St. Margaret Mary, and it's a morning assembly. Everybody's lined up in rows in their Catholic school uniforms, perfect rows. At one point, my daughter was out of line. The principal came over to talk to her about that. So, typical, beautiful, wonderful, organized and disciplined Catholic school. Love it over there. And after morning prayer, I want to make sure I'm on time for morning prayer. So I skipped a few details like combing my beautiful and illustrious hair. So I put on my New York Giants cap because I'm a New York football Giants fan. Other Giants fans in the room? No, we tend to hide. Yes, it's not been a good year for many years for Giants fans, but I've got my Giants cap on because my hair's not as prim and proper as you see it before you at this moment. And I'm not in my business suit yet either. So I look pretty bad. But the kids are on time. We're all on time. And I'm leaving and I get an email, bar counsel's investigator who's talking to my client for the second time this afternoon. He wants to reschedule. Sounds good to me. So I email back real quick, no problem. April being at 9, because it's about 5 minutes to 8 at this point. April being at 9, she'll reschedule with you. No hard feelings, don't worry about it. Gotta keep bar counsel's investigator happy if you can, because he's investigating my client, so I don't want him upset. And then I realized my afternoon just freed up. And as I realized that, I also realized that I'm outside the chapel that folks are walking into to go to morning mass. And now I'm saying to myself, Patrick, what is your excuse at this point? You're standing outside the chapel and your afternoon just freed up. So, of course, I walk in to the chapel because I'm out of excuses. But what I also forget is I've got my baseball cap on. Yeah. So I'm there. If you're a Catholic like me, a lot of calisthenics involved, right? We stand, we sit, we kneel, we stand, we sit, we kneel, we stand. We pray with our whole bodies. Finally comes the kiss of peace, which has been renamed because we're not kissing each other anymore. We're shaking hands. Right? I'm shaking hands and I hear Patrick. Somebody's yelling my name back there. I don't know. But I go to shake Father Walsh's hand. And instead of hand out for the handshake, going like this because I've got my baseball cap on. I've forgotten it was there. So I'll rip that off my head real quick. And that's when the guy behind me was like, yeah, that's what I was going to tell you. But it's at that moment that I realize that I got my baseball cap on. But it's also at that moment that I realized that I was just listening to the radio yesterday. I don't know if anybody listens to AM 1080, Relevant Radio. Anybody? No? Great station. I just listened to the radio yesterday, and they're broadcasting live their mass from Wisconsin, Our Lady of Good Help. It was the anniversary of that Our Lady of Good Help. And the sermon in that radio broadcast from just yesterday, the priest was complaining about somebody wearing his baseball cap at mass. So as I'm ripping this cap off my head, and my buddy behind there, hey, Patrick, yeah, that's what I was trying to tell you. It occurred to me, I didn't really learn the lesson of yesterday's radio broadcast. So maybe you've had that experience on a midterm. Maybe you've looked at the question and you realize, that's when you realize, I haven't learned the lesson, So I hadn't learned the baseball cap lesson, apparently. So maybe in one of your midterms, maybe you realize you hadn't learned the lesson. And life can be that way sometimes. Events come at you. Tests come at you, situations come at you, baseball caps come at you. And that is when you finally realize that you didn't learn the lesson you're supposed to learn. So as I'm driving back in the car, to head back home, make my hair prim and proper, put on the beautiful business suit that you see me in today, I'm starting to think, what other lessons in life have I not yet learned? And I stopped myself from that conversation in my head very quickly because the list was quite long. Maybe that's true for you too. And I don't want that list to be long. Maybe you don't either. Because we've got this one life. We've got this one here and now. And we've got this one ultimate purpose in the here and now. And that's to serve the Lord your God, to know him, love him, and serve him in this world so that we can be forever with him in the next world. And whether it's my baseball cap or all my other behaviors, so many of which you've unfortunately witnessed firsthand, I'm a deeply flawed individual. I am. And I've got a way to go. I do. So I guess ultimately I'm thankful for these instances. Maybe they're humiliating, maybe they're embarrassing, maybe they're a wake-up call. But in a way, we all, from time to time, need that wake-up call. So whether it's a graded midterm exam, whether it's a New York Giants baseball cap on your head in the middle of the holy sacrifice of the Mass, whether it's anything that happens to you, you've got an opportunity there. You've got an opportunity to make the most of it. Now, there's a mandatory curve in this class. Some of you will have an A, others, most of you, the vast majority of you will not. And we shouldn't let these letter grades define us. I look back at some of the most successful individuals that I went to law school with. I see them on the news. I see their noteworthy achievements. And for the most part, they were not the A students in my law school. Some of them were, most of them were not. Don't let these letter grades define you. But let these opportunities, whether it's a midterm, whether it's something else you messed up, like a baseball cap on your head, let them be an opportunity for you. Let them be a chance to change your ways. So that's my prayer for you today. And for whether your lesson's a baseball cap or a midterm, I hope you can make the most of it. Hope you can find a way to let it transform you on your path towards holiness, to let you be the woman or man that God made you to be. So with that said, I'll offer you this prayer. In the name of the Father, and the Son, and the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto you, O Virgin of Virgins, my mother. To you I come, before you I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in your mercy hear and answer me. Amen. Father, Son, Holy Spirit, amen. Okay, we've got an attendance sheet that needs to go around. Does anyone have an attendance sheet? Okay, can you make sure those who are here sign in? Those who are not here do not sign in. And those who are with us in spirit, if they have a spirit that can sign, then that spirit should shine. I'm working on that joke. At some point, the attendance joke is going to be funny. I'm just going to keep working on that until we get to the point that it's funny. But I left you all with the question as we were wrapping up chapter 3 of our textbook. This question has been on your mind. You've been dying to know. You've been blowing up my phone, filling up my emails, texting me day and night. McGinley, tell me the answer to this question. Actually, I didn't get any text emails or calls. But the question went something a little like that. Perhaps nothing in the law is more cherished nor more protected than our constitutional rights. So does that mean that the victim whose constitutional rights were violated is entitled to free legal services? What about one who can't afford a lawyer? For example, the criminally accused, they get a public defender. So don't constitutional law violation victims, don't they get one too? And who can tell us the answer to this question? Where is the con law public defender's office? Yes.
You don't get one, no.
Yeah, we don't have a con law public defender's office, do we? We don't. And the answer is yes, you wish there was one.
No, for the ACLU.
Okay, so you're mentioning some of these public interest groups, and I guess that is one way. Well, when we look at that principle of subsidiarity, we see that sometimes local problems need local solutions. Sometimes we don't need the highest authority to step in and micromanage every local problem. Sometimes there can be groups such as nonprofits, churches, synagogues, mosques, charities, families, private corporations, LLCs, who can do jobs like that. So I see what you're pointing out when you mention that group. That's one among many groups that might fill this void, if you consider this to be a void, of a lack of a common law public defender. That's a great point that you raised. But the American rule applies. Each side bears its own attorney fees, win or lose. And this is true even for something as egregious as a violation of our constitutional rights. The exception is when there is a statute or administrative code rule that creates attorney fee entitlement. And when we talked about our hypothetical client, been wronged, that was a violation of the Florida Civil Rights Act. And in that act, Chapter 760 of the Florida statutes, we see one such example. There can be attorney fees awarded. And that attorney fee provision in Florida statutes, Chapter 760, is interpreted consistently with 28 U.S.C. Section 1988, which can create attorney fees in certain circumstances. And we talked a little bit about the details of some of those circumstances in our last lecture when we discussed been wronged. But the point I wanted to drive home is, despite our sympathies for those whose constitutional rights may have been violated, despite the importance of vindicating violations of constitutional rights, that in and of itself is not enough to change what's been called the American rule, to change the common law, to change the fact that each side bears its own attorney fees, win or lose. Instead, you'll need a law, you'll need a statute, you'll need an authority to cite to, and you'll need to meet the requirements, the elements of the action under that authority or law in order to shift attorney fee entitlement so that the opposing party pays. You've got to meet those requirements. You've got to assert that affirmatively. And that's the point I wanted to make there. So just a couple things to wrap up here in Chapter 3 before we can move on to Chapter 4. Let's do those, shall we? Here we've got one of my more important topics to cover in Chapter 3, but yet it's at the end of the book. Maybe I should, or the end of the chapter, maybe I should second guess that. I want to talk about facial versus as applied, challenging a government act or action on its face versus challenging it as applied. And what are we talking about there? We're talking about, oh, yes.
Just remember that this was a question on the midterm.
Yeah.
Okay, did you get it right?
No.
Okay. I feel like I got a baseball cap on my head for some reason. We will address this. We will fix this. We're going over the midterm on Thursday. Perhaps it had 8 questions. Maybe.
I got a solution. Let's just go through the midterm together, find out one question that everyone got right throughout the rest.
Oh, that's excellent. That's an excellent suggestion. And who could be dissatisfied?
Exactly.
All right. Well, we will address these things. I don't mean to dodge the question, but I will table the question with your permission because we've got that topic on tap for Thursday. All right. And I want to make sure we don't talk about the midterm before everyone's taking the midterm. That's important. That's a good excuse like that. Made that off the top of my head. I'm a thinking cap on that time. All right. So let's talk about something you already know. And that's on its face versus as applied. So on its face, as applied, what's the difference? Why bother knowing? Let's talk about this in detail. Now, I like to compare and contrast on its face versus as applied. In so doing, I don't want to imply that one is easy and one is difficult, because both are difficult. God bless you. Both are difficult. As you know from our studies of our canons of construction, with certain exceptions, a law is presumed to be constitutional, and the court is obliged to read it in such a way, God bless you, as to be constitutional, with certain exceptions. You remember that lecture. So for that reason, it would be inaccurate to call either on its face or as applied to be an easy case, because in neither is it easy, because the presumption is against us. With that said, to attack an act or action on its face would be the more difficult of the two, relatively speaking. This is the more difficult of the two. What we're saying here is that this act or action, as it's written, cannot be applied to anyone without violating the Constitution. If it's unconstitutional on its face, then it can't be applied to anyone in any circumstance without violating the requirements of Florida's Constitution. What we're saying is that it is unconstitutional as to all and in all circumstances. This is what we're saying when we're arguing that the act or action of the government is unconstitutional on its face. The burden here for he or she who's arguing that it is unconstitutional is to prove it is unconstitutional regardless of the circumstances. So therefore, if the defense were to come forth with a single instance where this act or action could be applied against a particular individual or group of individuals without violating the Constitution, then your entire facial attack, your entire on its face case fails and is defeated. How can I illustrate that through an example? Let me turn, if you will, to hyperbole. Imagine, if you will, you've launched litigation and you're at trial arguing that a particular Florida statute violates Florida's Constitution on its face. And you have 30 days of trial. 29 and a half of those 30 days were you offering witness after witness after witness and proving beyond a reasonable doubt, remember this is hyperbole, beyond a reasonable doubt that their rights have been violated. Finally, the defense offers just a half hour of testimony. An individual from the community whose rights are not violated by that statute applied to them. Look at the overwhelming amount of evidence that was in your favor, 29 and a half days. The defense offered just a single instance. Who wins that facial attack? The defense has won. The defense has won. So by using hyperbole, I hope I'm illustrating a facial attack. Why then would you launch a facial attack? Why then bring the claim on its face? Well, one potential reason would be the greater relief available to you. The relief, if you succeed, is that the statute is in effect nullified. In effect, you've stricken it from the books. It can't be applied to anyone in any circumstance if you have successfully litigated the fact that it is unconstitutional on its face. Again, let me turn to hyperbole. Let me make up the story of the magic eraser. Imagine, if you will, there is a magic eraser with wings, got big wings, right? It can take flight and it can visit every law library, yours here on campus. When you work at your law firm, it can visit there too. It can even go to the internet, which is where most people read laws nowadays, right? And the magic eraser, if you win, would fly and erase this statute from the books. Because in a sense, that's what happens. There is no magic eraser, by the way, just in case you were wondering. But in a sense, that's what happens if your litigation is successful. Because even though you just represented one plaintiff or one group of plaintiffs, you've proven that the act or action is unconstitutional on its face, and therefore it in a sense becomes a nullity because it can't be applied against anyone in any circumstance if you succeed. Compare that, if you will, to an attack as applied. Now, again, I'm speaking relatively. Neither of these is easy to win, but generally, relatively speaking, this is the somewhat less difficult case. Like the way I phrased that? I didn't use the word easy. It's the somewhat less difficult case. What we're arguing here, if we argue our case as applied, is that for my particular client, for this plaintiff of mine, and if you will, you could go a little bit further. You could say, for this plaintiff and all those similarly situated to this plaintiff, if that's what you'd like to argue. But for this plaintiff, under these facts, And in this circumstance, the Constitution has been violated. Applying this statute to this plaintiff in these circumstances results in a violation of constitutional rights. You see the difference there in the phrasing of the argument. Makes sense? What we're saying here is that only in this instance, under these facts, has the Constitution been violated, and we're not arguing further. This sets the defense, so to speak, insofar as it will be insufficient under this as-applied argument for the defense to come forward with a litany of examples of ways this law could be applied against different individuals, not similarly situated, without violating the constitutional right. That proof by the defense would be insufficient to win the case. To illustrate that again, forgive me as I reach for hyperbole. Again, you're putting on your trial. You've got a 30-day trial. You're arguing as applied. Of those 30 days, you've used just a half a day. You've put on the testimony of your client. God bless you. And then you rest. And for the next 29 and a half days, the defense puts on witness after witness after witness after witness and proves, again, beyond a reasonable doubt, it's not the standard here, proves beyond a reasonable doubt that there have been no constitutional law violations as applied to these myriad of individuals. At the end of that 30-day trial, did the defense win? No, because your burden was simply to prove that it was unconstitutional as to your client, in your client's circumstances, as to this plaintiff, in this plaintiff's circumstances. Now, for the as-applied argument, the relief is different. The relief is less. The relief is that the statute remains on the books and applicable to any and all individuals except your client, the successful plaintiff, and except those who can prove they are similarly situated to your client. So again, to return to my magic eraser story, if there were a magic eraser, it would not fly. Nothing would be erased after a plaintiff succeeds in an as-applied litigation. Indeed, will the government continue to enforce the statute against those who are not similarly situated to the successful plaintiff? Yes, they will. Will they be violating a court order by doing that? No, they won't. So I hope as we compare and contrast, you can see the difference between on its face versus as applied. Did that make sense to everyone? What questions does that raise other than the one that was on the midterm? So we've got it? It makes sense? All right. So let me ask you this then. Yes, well, you've got a question. Yes.
Sorry, I'm kind of confused about the last
Okay, let me flip back. It's on its face. I'll put on the face of this wall, I'll put on its face. I had to reach for a pun there. Forgive me. It's not punny. I understand.
So the defense just has to bring one person to keep it as like a good law. Is that what?
To win the case? That would win the case. Because the plaintiff's burden is to prove that it's unconstitutional as to all in any circumstances. If the plaintiff is arguing that the statute is unconstitutional on its face, it's not true that it's unconstitutional on its face if there are those against whom the statute can be applied without violating any constitutional rights. Admittedly,
No, I understand now.
it's a little counterintuitive perhaps. You think of something as unconstitutional as being yes or no, as on or off.
Maybe.
And indeed, with a on its face argument, you are arguing for on or off, applied or not applied. But what you're doing there is you're saying that this statute, if you're arguing on its face, this statute can't be applied without violating the Constitution. There are times when a statute is written, perhaps even the drafters didn't foresee an application of that statute that would violate any constitutional rights. And perhaps in most instances, that statute doesn't violate any constitutional rights, but there are a plaintiff or a group of plaintiffs whose constitutional rights are violated. That's when we need the relief of an as-applied challenge.
Because I was thinking like an abortion law wouldn't be unconstitutional to a man. You know what I mean?
I hear what you're saying.
So I was thinking,
Yeah.
Then they could just, the defense could just bring on a guy.
Yeah.
So I don't know. Maybe.
No, that's an excellent example. But for those who are affected by it, that fall into that group of plaintiffs, if you've succeeded in the as-applied challenge, you've certainly succeeded for your client, and indirectly you've succeeded for all future individuals, current and future individuals who are in the similar circumstance, who are similarly situated. Why do I stumble over that? Similarly situated. Okay, similarly situated to your client.
No, I totally get it.
Okay, yeah, but thanks for helping me work through it. Hopefully it helps others. Yeah,
No, I was just gonna comment, like, to act as devil's advocate to what she said, is if
Yeah.
you were to take an abortion statute, on its face, it's not, it would never apply to a man. So you'd only be looking at the category
Okay.
of individuals that it impacts, which would be women. And if you could find, like you say, an instance where it was constitutional, then on its face, it's not unconstitutional.
right. Well said. Everybody get that? Okay, well said. So my question to you then, why bother to ever assert something's unconstitutional on its face? Why not just assert that it's unconstitutional as applied? Now remember, when I compared and contrast, neither was easy, but the less difficult case, remember, the somewhat less difficult case was as applied. So why not always argue as applied? Yeah,
So if you want to change precedent, change the law as it is, the relief is greater. It changes the law by getting rid of it, and it can be eventually replaced by new legislation.
well, that's a great answer because you want the greater relief.
Yes.
And of course, we have to keep in mind what our client wants. So I guess I should rephrase that. Our client wants the greater relief. And it's important, of course, we talked about in our last class, we talked about attorney ethics, that the lawyer is not a tool. The lawyer determines the means by which to achieve the client's litigation objectives, but it is the client who has the final say as to what the objectives of the litigation are. So yeah, this is an issue you may want to raise with your client so that your client can make an informed decision as to what relief your client is after. For some people, they've got their mind on their money and their money on their mind. And maybe they just want to win the case. So as applied sounds great. For others, they may have a different goal. Maybe they're out to change the world. So for that client, on its face may be the better case. This is something that's going to differ on a case-by-case basis. And because our clients have the ultimate say as to the goal of the litigation, something we need to talk to them about. Make sense? All right. Let's try another topic. Oh, we had a couple notes and questions to consider. Yeah, where are they? Okay. All right. Note and question to consider. Note 1. A new client of your law firm is affected by a Florida statute that does not appear to be unconstitutional on its face. Speaking of face, I read a lot better with these on my face. Okay. The way a statute affects most people, this particular statute affects most people, is not in violation of their Florida constitutional rights. But the way this statute affects your client appears to be in violation of your client's Florida constitutional rights. Should you challenge the constitutionality of the statute on its face or as applied? Yeah, because you have a higher degree of success there. In fact, you probably, under these facts, couldn't succeed on its face, like my glasses. Yeah. How does your choice affect the legal burden to be carried by your new client and by the defendant? Yes.
If you're doing as applied, it creates more of an onus on the defendant to show that it's not unconstitutional as applied. It's easier for you to show that in this instance that it's affecting your client and similar situated clients to that effect.
Right. In a way, you assert a bit of control over the defense. There is good case law precedent that would say that on an as-applied litigation, it would be legally irrelevant to offer testimony by the defense of someone who is not similarly situated to the plaintiff. A good judge, in my opinion, would respond to your objection as plaintiff's attorney of objection, irrelevant, would respond with sustained if you're objecting to testimony from someone who's not similarly situated to your client if you're making an as-applied attack. So you might be able, through discovery, to identify evidence that might be plugging at the heart of the jury, that might be not persuasive toward your case. By choosing as applied, you might be able to exclude that evidence as irrelevant and keep it out of your litigation, depending on the particular facts of your case. So I like your answer. Last question here in part one was, how does the choice affect the client's potential legal remedy? What if your client's goal is to let that flying eraser fly? Then you're going to need to attack the statute on its face, right? Okay. Note 2, the Florida rules of civil procedure permit pleading in the alternative, and therefore it is permissible in a single lawsuit challenging a single law to allege it is unconstitutional both on its face and as applied. Is this always the best strategy, or are there risks to this strategy? One risk I can think of was the other side of the coin that I just talked about. When it comes to an as-applied attack, might give you the ability to exclude certain evidence as irrelevant from your constitutional litigation that would not successfully be excluded as irrelevant from an on its face litigation. So that might tempt you or alert you or persuade you to choose one or the other and not to plead both in the alternative. All right, that's note 1. Note 2. Let's wrap up our chapter by considering amicus, which I've sometimes heard pronounced amicus. Anybody here speak Latin? Latin speakers? No, e pluribus unum? Yo, you speak Latin.
No, I don't. Sorry, I thought your next question was going to be what does it mean, but
Yeah, that's my next question. What does it mean?
friend of the court.
Yeah, I like that. Friend of the court. That's what we're talking about there. We're on the bottom of page 121. Is a person or group who's not a party to the appeal, but wishes to be heard in it. When you studied federal constitutional law, when you took Con Law 1, all you had to bring to class were those 34 pages of the text of the U.S. Constitution, right? That's what you studied during that 4-credit-hour semester, right? No, you had this big, fat, thick book full of what? Case law precedent from the Supreme Court of the United States almost invariably. Why is that? Because sometimes case law is the law, is it not? Sometimes case law is the controlling precedent. Sometimes our rights or lack thereof derive not from the text of our Constitution, or for better or for worse, they derive from case law precedent, and then from precedent that interprets that precedent, and then from precedent that interpreted that precedent, that interpreted that precedent. And at some point, you'll wonder, is anybody even reading the text of the Constitution anymore, right? Right? But yeah, so with that in mind, that for better or for worse, judges sometimes make laws instead of calling balls and strikes. For better or for worse, that happens sometimes, and I'll keep my personal views out of it. It's either for better or for worse. I'll let you decide whether it's for better or for worse. But sometimes judges make law, and there are those who like to sugarcoat that. But can you, with intellectual honesty, can you sugarcoat that? Aren't there certain rights, duties, responsibilities that exist only in case law precedent? I would argue they are. So perhaps for that reason, rules of procedure often allow for amicus, and indeed the Florida rules of appellate procedure are no exception. One can intervene, so to speak, and become a part of a case where you're neither plaintiff nor defendant, where you're neither appellant nor appellee, whether you're neither petitioner nor respondent. You're not a party, but you can put your 2 cents in if you're allowed to be amicus. Let's take a look at that. Where we look at CIBA-GEIGY, CIBA-GEIGY. Someone pick a pronunciation. I'll run with it. CIBA. Okay, CIBA. You didn't do the other one though. CIBA who? GEIGY. CIBA-GEIGY. All right. And my apologies to the good folks of CIBA-GEIGY Limited for my ignorance and not knowing how to pronounce their name. So CIBA-GEIGY Limited versus Fish Peddler was an order on a motion to file amicus curiae briefs, and I thought it was interesting. So here in this case, they've received to date motions to file 2 amicus briefs. Briefs from amicus, which mean friend of the court, are generally for the purpose of assisting the court in cases which are of general public interest or aiding in the presentation of difficult issues. Although by the nature of things, an amicus is not normally impartial, quoting for a First Circuit 1970 decision there, amicus briefs should not argue the facts in issue. So there's one restriction upon these non-parties who've shown up and thrown themselves into your case. First thing they can't do, they shouldn't be arguing the facts in issue. In the present case, one of the amicus briefs appears to be nothing more than an attempt to present a fact-specific argument of the same type as is contained in the appellant's 50-page brief. Since the parties are limited as to the number and lengths of brief, amicus brief should not be used to simply give one side more exposure than the rules contemplate. So another consideration of the courts is one of equity. Will letting an amicus in provide an unfair advantage to one side or the other? We therefore deny the motion to file an amicus brief on behalf of the Florida Chamber of Commerce. Because our time for reading briefs is not unlimited, oh, excuse me, Your Honor, it would be helpful to the court if amicus would attempt to join together in one brief and cooperate with the parties so as not to be repetitious of the parties' briefs. In the interest of brevity, amicus brief should not contain a statement of the case or facts, another requirement of the amicus, but rather should get right to the additional information which the amicus believes will assist the court. Although Florida Rule of Appellate Procedure 9.370 does not require a motion for leave to file an amicus brief to state whether the parties have consented, it would be appropriate for the motion to contain that information. So here's some of the criteria the courts will use if someone wants to intervene in your lawsuit as an amicus. I remember one day I'm trying to enjoy my Thai food at Thai Place, literally the name of the restaurant, Thai Place. And on the phone is this guy who's about to file his motion. He represents the something association of something. Go ahead, let me put you down, says the guy on my cell phone. Put you down as unopposed because we're on your side. We're arguing the case. I said, I'm happy to hear that, but I am opposed. And you can't put me down as unopposed. You know, I won the case below. I felt I had a strong case for affirmance on appeal, and I'm in control. I was in control below when I offered certain evidence and not other evidence, when I objected to certain evidence and not other evidence, when I crafted a legal argument. And likewise, on appeal, I yet again am crafting a particular argument for the court's focus. I don't want someone whose interests are not the same as mine and my clients to recraft the case in their own likeness so that they can advance their own particular goals. My client's goal is what I'm after. And I've got a specific way to do it. And I didn't want amicus to be part. Court let him in anyway. But he voiced surprise, this other attorney on the phone. Oh, what? I'm on your side. What? You know? But I was more interested in making sure I got my affirmance than I was in having this guy achieve and his client achieve whatever their goals might have been. So that brings us to these notes and questions to consider. Which ones did I put on board? 2, 3, and 4. Okay, I skipped over note 1. Note 2. In your opinion, should appellate courts be more willing or more reluctant to allow amicus briefs in cases where the parties raise issues under Florida's Constitution? Who's going to talk to me about that? No, this is where everybody looks down and around. There's no wrong answer to this question. It's opinion, right? You're not looking down or around. And your hand's up. Maybe you'll both talk to me. Yes.
I'm going to take the stand that interest of the court, it should be more willing, looking at from the bench's perspective,
Okay.
providing the bench more information about what the relevant law is,
Why?
unless there's a chance for the judge to get overturned on appeal. So from a judge's perspective, absolutely, give me more information.
All right. Now, what about the loaded part of the question where it's the parties raising issues under Florida's Constitution? Would that, in your opinion, should appellate courts be more willing or more reluctant in such a case with such issues?
I would say, especially in matters to do with the Constitution, because it is such a high burden you have to do to change something, and the more information the court has, the more likely the court will get that constitutional interpretation right.
Yeah. And that kind of case is going to affect more than just the parties, right?
Absolutely.
So one of the beauties of the democratic process is that we elect these individuals who then eventually have to come home and try to get reelected. They're accountable to us, right? And in the meantime, they're casting votes. And they're casting votes in committees. It's not like there's one superhuman who gets to decide what the law is. There's many senators, many members of the House of Representatives, first in committee and then on the entire floor, and then finally have to send it over to the other house. There's, at that point, more than 100 individuals have taken a look at this law. And before they even vote, they're hearing testimony. They're hearing from their constituents. If they happen to be the chairman, they'll have certain witnesses so that the whole committee can hear from them. And this is how laws get made, in this very accountable way. Compare that on the flip side to laws that arise from a lack of judicial restraint, from where a judge who has been elected or perhaps even just appointed says, nope, here's what the law is. Everyone will follow it. And as we often see in the national news, maybe it's a federal judge, and that judge might be from the northeast, southwest district of one state, but their injunction applies where? Nationwide and worldwide. And we've elected these individuals who've decided to do this, but the United States District Court of the north, southwest, eastern corner of this state says, I hereby sign this order, and your elected officials can't do that anymore. It would be nice in a world like that if maybe these superhuman judges would hear from a couple of us first before shutting down our elected officials and enjoining them from doing what we elected them to do. Wouldn't that be nice? I think so. And amicus at least gives the potential that that might happen. Note 3, assuming a case is not generating media attention, how would people or organizations know about it in order to file a motion for permission to submit an amicus brief? And it's a loaded question because they're not going to know, right? They're not going to know. Note 4, if you were representing a litigant in a constitutional law case where an unexpected amicus filed a motion for permission to submit a brief in your case, what would you do? Would you object? Would you seek to join together or coordinate with them, as the CIBA-GEIGY versus the fish peddler suggests? What would you do? You're going to be practicing law in the state. It's going to happen to you. You're going to have to make a decision on that. So that wraps up chapter 3. Hope you enjoyed it. Chapter 3, like chapter 2, was very nuts and bolts. Chapter 3, like chapter 2, was a how. And as I started this class and I made you that promise, we'd do more in this class than just be able to identify a constitutional law violation and lament that there's been a constitutional law violation. We would also have an understanding as to how to actually do something about that constitutional law violation. And I, in part, began to keep that promise with chapters 2 and 3. I'm not going to abandon that particular focus. But at the same time, as I move on to chapter 4 now, and we look at Florida's Declaration of Rights, Article 1, should be a Roman numeral, Article 1 of Florida's Constitution, we're going to be talking about some of the big issues. That was another part of the promise I made. Sister Rosemary Finnegan was standing here. I promised that I wasn't going to avoid the big issues, that we're going to tackle them head on in this class. And in society nowadays, we don't really talk about the big issues. If you turn on the news, if you see what people are talking about, invariably it's either social media, sports, or the weather, right? We're all talking about the weather. The weather's too hot. Why is the weather too hot? Which companies cause the weather to be too hot? What are we going to do about the fact that the weather's too hot? Now it's cold. Now it's too cold. What companies cause the weather to be too cold? What human behaviors need to change so the weather's not so darn cold? Or we talk about social media, we'll spend millions. We'll have a special counsel to investigate and find out who put those ads on Facebook. Some Russians did that. Let's indict them. They've been indicted. I've never met them. I guess they won't be coming over here to stand trial, I guess. I don't know. But we're outraged. How dare someone fill our news feed, right? Some statements we don't like. And then there's sports. And started this class lamenting about my New York Football Giants. My friend's wearing a Florida shirt, which LSU's going to win.
Careful.
Here, see that? Now we have a heated debate, do we not? But sports, the weather, social media. Sports, the weather, social media. I'm not saying these things aren't important, but what I'm saying is sometimes they're a way to avoid tackling big issues that face society. The issues that we're going to be tackling, chapters 4, 5, and 6, almost without fail, none of them are new. All of them were faced by our father's generation and our grandmother's generation and our great-grandfather's generation and our great-great-grandmother's generation. Each generation kicking these issues down the road again and again and again. What I want to challenge you to do as we look at these big issues is to stop and ask yourself, am I part of that generation that's not going to kick the can down the road? Perhaps when you hear one of these big issues we talk about, you're not going to like the current status of the law. I have a suggestion for you, my fellow lawyers. You are in a unique position in our society to not just lament about what the law is, but to change it. To change it. Any American in our democracy can do that. But the lawyer is in a far better position than most to get that work done. So before we jump into chapter 4, I wanted to give you that inspiration. And the first thing we're going to talk about in chapter 4 is this question, which brings us back to chapter 1. Brings us back to that laboratory of democracy we talked about in chapter 1. That brings us back to that adequate and independent state law basis that we learned from the ruling of Michigan versus Long. We know from the Supreme Court of the United States decision in Michigan versus Long that a state's high court need not interpret language in that state's constitution exactly in the same way that that language is interpreted when it appears in the federal constitution. My question is this: does that mean that Florida's language in its Declaration of Rights is interpreted differently than identical language in the Federal Bill of Rights? Think about it. What if one constitution almost literally copied and pasted from the other? And historically, what we find is that the 13 colonies and their constitutions were quite inspirational upon the U.S. Constitution. So they didn't have Microsoft Word back then. You couldn't literally copy and paste. I presume they had scissors and paste. So I guess you could cut and paste, right? But you couldn't copy and paste. So if one was a cut and paste or copy and paste from the other, does that bind the hands of the successor? Do we have to have unanimity? Do we have to have homogeny? Do we have to have the federal government be the answer? Or is there room for subsidiarity? Is there a potential for a laboratory of democracy? Can there be a different interpretation of identical language in the state constitution? And the answer is that just because it's identical doesn't mean that you have to interpret it identically. How could you get to the point where the state constitutional language, a mirror equivalent of the federal, could have its own interpretation? And that harkens us back to chapter 1. That was the lesson of Michigan versus Long. That is where an adequate and independent state law basis can transform a state's constitution into that laboratory of democracy. So as we look at Article 1 of Florida's Constitution, as we look at the Declaration of Rights, what I want you to ask yourself is, this language, be it a mirror image or be it similar to the text of the U.S. Constitution, does it have the same interpretation? Stated somewhat differently, when I look at the text of Florida's Constitution's Declaration of Rights, Article 1, am I simply looking at superfluities? Am I simply looking at a shadow of the U.S. Constitution? Am I looking at something that is interpreted the exact same way? So that's the question I want you to ask. And let's start with the notes and questions to consider on page 126 and 127. Question 1, 2 rights in Florida's Constitution, Article 1, state that those rights are to be interpreted consistently with their counterpart in the U.S. Constitution. So here in Florida's Constitution are 2 examples of rights in the Declaration of Rights that state that they are to be interpreted consistently with the language you find in the U.S. Constitution. The first example was Article 1, Section 12. Quote, this right shall be construed in conformity with the 4th Amendment to the United States Constitution as interpreted by the United States Supreme Court. End quote. The second example there was Article 1, Section 17. It's a little bit longer. Quote, shall be construed in conformity with decisions of the United States Supreme Court which interpret the prohibition against cruel and unusual punishment provided in the 8th Amendment to the U.S. Constitution. Any method of execution shall be allowed unless prohibited by the United States Constitution. And here's the question about those 2 particular instances. Can Florida's courts interpret either of these 2 rights differently than their federal counterpart? Yes.
No.
What's the answer? The answer is no. You are correct. You were also going to say no. I think there was another no over here. That's right. The answer is no. The answer is no. You remember from our canons of construction, if our state's constitution says a way to do a thing, then doing that thing in any other way is unconstitutional. So our canons of construction tell us when we see language like these 2 examples, we don't have room for that laboratory of democracy. We don't have an opportunity for an adequate and independent state law basis. We are not independent on these 2 rights because they are inextricably intertwined. What are the correct words? Inextricably intertwined. They're all tied up like that. Yeah, you understand what I'm saying. Maybe right now is a good time for a break. Get my mouth working again. All right. Well, 5 minutes, 10 minutes. Which one you need? Somebody said an hour. That's not happening.
All right, just 45 minutes then.
Well, you're a good negotiator, huh? Let's go with 8. I'll see you in 8 minutes. All right.
What's that?
Huh?
So you got it wrong. So you got it wrong. That's what I heard.
No, it's fine. I just wanted to make sure that you did it. Okay. And then if that timeline works, that timeline works. Until Monday, for Monday. If you need more time, I'll take care of this. Okay. Do you need the hours for Tuesday? Yeah. Do you want pro bono, right? You graduating? No, you graduating in May? They're doing Tuesday. The pro bono hours. Yeah. Well, that's why I'm asking, because I can get the I can get Kate to sign it.
Well, they're not in March.
There's two different versions, so I don't know, but
Well, no, I
better
mean,
safe
I
than
just-
sorry. You have to file a variance. They won't let you graduate with your class. That's what some girl was complaining to Jonathan about.
You were gonna have to apply for things.
So, yeah, you can, as long as you have less than 15, you can do a violation. Right?
That's what she was wondering, that she doesn't know. She said that, Thiago hasn't been here and that he's on leave. So she doesn't know how, she didn't know how to get a hold of him so that he could sign it for her.
I've heard new applied a person who does juvenile.
No?
Let's look it up.
Well, you can plan for that, and then I can get Kate to sign that. She's only here Tuesday to Thursday. That's what I was asking, if you were trying to get them done for Tuesday.
How many are there? 3?
There's 4 documents. Total of 8.
It's tab popping.
It's 4 documents, 4 hours. You don't have it in here either.
That's how long it takes. Count it. Okay, thank you.
I use good beer.
Yes. Facial aesthetics. Yes, they were there.
Some BS.
But he's suspicious.
It just gives you everything, so I can figure out where to go. That's stupid. It's like, hey, graduate this much.
Oh, here we go. Once a week, and then she gets to
I knew, I thought it changed. I knew somebody was. Just kidding. Oh, man. This whole week off.
What is administrative assistant to mean? She's a level 2 is administrative assistant.
Okay, well, what?
Do you want me to get them the packet?
What do you think? How do you tell me?
They sent me a graduation transcript on it, blah, blah, bullshit thing, and I have it.
Steph is playing on Sunday.
Like, word for word, what is it? Nothing.
I am, I'm gonna create, you have these things to do. Right after.
It's March. It's a graduation. It says, pro bono requirement and return certificate of completion.
I mean, I'll ask if they're interested, but they'll already send it to me.
After.
I'm gonna tell James. He's like,
Graduating.
no, he's gonna be like, we ain't going to her party no more. That
It's obnoxious.
It is obnoxious. Everybody will show up. I don't have to either.
No, but
Laugh
they
at each
teach
other.
you. No, they teach you. It's crazy.
But we just laugh at each other's funny. This is brand. Why are you showing me some shit that I didn't even know?
Because when you see something like this, it comes on your face, it's not just listening to it.
True, okay, some people,
Are you recording my graduation party
on that Friday?
It's literally,
Yeah.
it'll take for one store.
That's it.
Midnight.
All the
it's an actual.
I'm going to take a
Wow. I literally sat in the middle of them. You said you had a pirate thing too. You didn't send me that.
And plus, it's gonna be cheaper for you.
Yeah. Because they put in here prior to fall.
That's good or third grade. Big bang on the ground.
Oh, I have this one.
I don't remember what they said it was.
They have the students before 12/15, so there's literally no one here. And that's in the way. But no one's reading that. They're all reading, okay, if I'm graduating in the spring semester, I have this. Why would they, this needs to be up here. You know what I mean?
This is what you're wearing?
Yeah, I'm wearing I'm wearing this one with, so experiential and skills requirements, it's like mediation and bankruptcy clinic.
How?
That's literally what I did this summer, just because. It just had.
Yeah, my cheese sticks are like $10. Maybe it's $7, but still.
Wow, what time is it for college? Ma'am, I have a,
Everyone who's here on this sign-in attendance sheet. If you're in attendance, are you on here? Because if you're not here, then you're not there. Okay.
I know they have it.
We all back from break? We ready? I'm not sure.
It's been a long week.
I'm not sure y'all are ready. And I think that's what it is. Yeah. I heard that. It's been a long week. I understand that. So midterms week ended what, yesterday?
Yeah.
And then you're back here.
Yeah, first.
Yeah. Okay. Well, you know, I talked to Fred Trable. He did a good job, I hope. Fred Trable lectured here earlier.
Wait,
Is that
the
the?
criminal defense guy?
Yeah.
That was a fun one.
Good. Yeah.
He was
You know,
supposed to tell you that we were prepared.
no, he did. No, he seriously did.
He said we were one of the
He's
best.
been helping me
but I
out with
don't-
every class and doing a guest lecture for me for 2016 to the present. He thought this group was among the smartest I've had. So I have no reason to disagree.
It was fun.
So with that nice compliment and sugarcoating out there, just want to point out that nobody seems prepared today. Nobody.
I read. Well, I read.
And I understand. I've been there, and I know that it's midterms week ended just hours ago, right? Your mind's on your midterm, and your midterm's on your mind, right? Yeah. But some of my favorite topics are here. You know, we're just 2 pages away from freedom of religion, establishment clause, free exercise clause, church autonomy, religious discrimination, and what I hope after this next Supreme Court term might be a thing of the past, Blaine amendments, the no aid clause that we see in Florida's Constitution. I got great cases to cover with you, like Malachi versus Archdiocese of Miami from the DCA 2006. And I've also got the Florida Religious Freedom Restoration Act. We can talk about Warner versus City of Boca Raton. These topics are too important to be given short shrift. And y'all just aren't prepared today. So I hate to move the syllabus, but I'm not going to give some of the more important topics in this class short shrift. So we're going to leapfrog over these. But in return for me doing that, y'all are going to do me a favor. You're going to be prepared next week, and we're going to be able to discuss these topics that I just mentioned and these cases that I just cited to you. So when I call on you at random, and if that's what I got to do to make sure y'all are keeping up with the material, then that's what I'll do. When I call on you at random next week and I mention one of these cases, you're going to be able to brief it to me, and we're going to have an intelligent conversation about these topics. So with that said, I'm going to carve out what was intended to be part of today's lecture. We're going to cover that next week. Me, no disrespect in putting it this way, but you all have sacrificed to be here. All of you graduated from a great university, got a great bachelor's degree, could be working at a great salary right now. But instead of doing that, you've taken that opportunity cost, and on top of that, you've added the tuition, private Catholic school tuition on top of that. So I know it's as important to you as it is to me that you really get this material, that you're well prepared, not only for the bar exam, but for law practice. So I understand it's midterms week. I mean, no disrespect, but let's come next week better prepared than we are this week. Can we have that agreement?
Yeah.
We're all in agreement on that. And I hope I haven't been disrespectful, but at the same time, I hope I've got my point across. Okay, all right. So let's take a look then at equal protection. We're talking about Article 1, Section 2 of Florida's Constitution. And in a separate chapter, appearing later in this text, we're going to take a closer look at equal protection as it's interpreted under Florida's Constitution. And in that separate chapter, we're going to take a look at conclusive, or what the case law sometimes refers to as an irrebuttable presumption. These conclusive presumptions, these irrebuttable presumptions. And I'm going to carve that out in a later chapter and give it to you as an example of where there may be an instance of that laboratory democracy, of greater rights under Florida's Constitution's Equal Protection Clause than there is under the federal Constitution's Equal Protection Clause. And that is yet to come. So, but simply stated here, we look at Florida 1990 Supreme Court decision in Shriners Hospital versus Zrillick, Zrillic. Their equal protection guarantees from Florida's Constitution should be interpreted using the same analysis as the Supreme Court of the United States uses in interpreting the federal Constitution. So if we simply focus on Shriners versus Zrillick, what we have is nothing more than superfluous language. We have nothing more than a mirror image with an identical interpretation. But as I'll carve out for you in greater detail, I think, and I'll make the argument for, and you'll decide whether I'm right or not, that there is a greater right when it comes to the civil law, not just the criminal law, but the civil law, and how here in Florida we have protection from a civil law conclusive presumption or an irrebuttable presumption that doesn't exist in the civil law under the federal Constitution. So that's what we have there. Then some of my favorites: freedom of religion, free speech in the press, the right to assemble. As I mentioned, we're going to cover these in our next class when everybody's ready to dive right into the depths of it. Yes.
I'm sorry, so what was I didn't hear all this in this time until law chapter.
Oh, yeah. Well, I really was interested in having an in-depth conversation with all of you participating when it comes to those freedoms akin to First Amendment rights. You see this beginning on page 128. So this is chapter 4, subsection C as in cat. And under subsection C comes subsection 1, freedom of religion. Under that comes subsection A for the Establishment Clause, B for the Free Exercise Clause, C for the religious discrimination, and the No Aid Clause or the Blaine Amendments, D for church autonomy. And you see this continues through E, the Florida Religious Freedom Restoration Act in the case of Warner versus City of Boca Raton from the Supreme Court of Florida in 2004. And so what I'm talking about there ends roughly on page 150. So I really want to have an in-depth conversation on that. So let's do that next week. Sound good? All right. So that brings us to page 151. And here we've got a contracts clause. Oh, protection from search and seizures, imprisonment from debt, right to bear arms. Where is my contracts clause? There it is. Protection from impairment of contracts. So let's take a look at that. So what we've got here is Article 1, Section 10, prohibited laws. And that has a few different things in it, as you can see. It's been listed all here, but what I've carved out to talk about is no law impairing the obligation of contracts shall be passed. So we know from the Constitution of the United States, the federal Constitution, Article 1, Section 10, Clause 1, there, that prohibits states from passing any law impairing the obligation of contract. Comparing and contrasting that federal right with the contracts clause in the Florida Constitution, you've got that case of Pomponio versus Claridge of Pompano Condo. That's a 1979 decision of Florida Supreme Court. And here's the language I wanted to highlight to you from that decision. You can see it in the middle on page 150. We recognize that this court, when construing a provision of the Florida Constitution, is not bound to accept as controlling the United States Supreme Court's interpretation of a parallel provision of the federal Constitution. Yet, such rulings have long been considered helpful and persuasive and are obviously entitled to great weight. With this in mind, we now choose to adopt an approach to contracts clause analysis similar to that of the United States Supreme Court. That court's decisions in this area of law convince us that such an approach is the one most likely to yield results consonant with the basic purpose of the constitutional provision in Florida's Constitution. So talk to me about that language. To what extent has the Supreme Court of Florida become a laboratory of democracy when it comes to offering no less than the full panoply of federal constitutional rights under the contract clause, but experimenting with granting its citizens greater rights under the contracts clause? Yes.
I was just going to say that, they're pretty much putting, they're going to use them as a guidance, but they are allowing themselves the freedom to interpret something different so long as they meet the minimum requirements by the U.S. Constitution.
Yeah, I see that in there too. But to what extent now has this quoted language from the opinion opened the door to granting greater contract rights? I don't know whose hand was up first. Yes.
Well, it goes to the fact that that they chose to, Florida court chose to make their interpretation similar to the United States. They, while they're saying that it's got the great case law and the great weight behind their interpretation, they're saying that using that word similar lets them not have identical, because once they state that their interpretation is identical, then they no longer can deviate from the federal standard.
So you're highlighting the choice of words similar, and you see that there's a crack in the door. There's an opening. There's a slight opening here. Okay. All right. And did you have the same opinion or a different opinion?
Similar.
I don't know whose hand went up first. Yes.
Very similar. I was going to compare this almost to the Kelly case, and it's showing primacy by Florida state law. It's going to look at Florida protections first, and use the federal as highly persuasive authority.
Okay.
Therefore, as long as it falls under the full panoply, you can afford more rights for the Florida Constitution.
So you're going back to those adjectives we introduced in chapter 1. You see this as a primacy approach?
Yes,
Okay. Primacy of,
Florida state law.
okay, all right. So you interpret this to say that this is a primacy approach insofar as the court has left open the opportunity for different interpretation, but has found persuasive the existing interpretation that SCOTUS gives us from the federal Constitution. Is that a good
Yes.
combination of what the two of you are saying? Okay. How does everyone else react to that? Is this how a state's high court, such as the Florida Supreme Court, can best serve as this laboratory of democracy? What's your opinion on what the court has done here? It is, if our analysis is correct, it has left the door open to a different interpretation, but it has certainly found SCOTUS's opinions to be helpful, persuasive, entitled to great weight. Where would you put this on, if you would, a scale? Imagine a scale, a range, if you would, from a true and pure experiment in the laboratory of democracy on the one hand of the scale, where the state's stated goal is to try to experiment with giving its citizens greater rights under the state constitution, all the while never denying any of the full panoply of federal constitutional rights. That could be this end of the scale. Let's move to the opposite end of the scale. On this end would be some of those examples we gave earlier, where in the text of the Constitution it required, and therefore our canons of construction require, that the state constitution be interpreted exactly as the federal constitution is interpreted by the Supreme Court of the United States. So if we imagine this is our scale, where would you put this particular case on that scale? I hope you'd agree that it's not over here on this far end of the scale, because it doesn't say explicitly we're always going to interpret the contracts clause under the Florida Constitution exactly as the Supreme Court of the United States interprets the contract clause under the Florida Constitution. Agreed? Are we agreed on that? So it's not right here. Is it all the way at the other end? You're shaking your head. Why not? Why is it not all the way over here?
Somewhere in the middle.
It's somewhere in the middle.
Yeah.
And before we decide where in the middle, tell me why it's not over here. Why is it somewhere in the middle?
Because they don't deem it to be exactly like the federal constitution, where federal law, they were leaving room open to be able to bring about their own decisions.
Yeah. They've left room open, but they haven't taken their own path. You understand, do you not, that if the requirements of Michigan versus Long are met, a state's high court can do more than what you just heard Florida Supreme Court doing in this 1979 decision of Pomponio versus Claridge of Pompano Condo. It can do more than just crack the door a bit, leave the door open, leave the potential. The state's high court can take its own independent path if it does so by having an adequate and independent state law basis as defined by SCOTUS and its decision of Michigan versus Long, which we studied in great detail in chapter 1. What that means is that the state high court can never interpret its state's constitution to provide its citizens with anything less than the full range, the full amount, the full panoply of federal constitutional rights, regardless of the origin of those federal constitutional rights. Our federal civil rights, our federal human rights derive from the text of the U.S. Constitution, derive from the United States Code, derive from the CFR, the Code of Federal Regulations, derived from case law precedent, derived from various federal sources, all of which have to be honored and abided by state high courts, regardless of what the text of their constitution might say. And Florida is no exception. But so long as the state high court abides by all those federal human rights, civil rights, constitutional rights, regardless of their federal origin, abides by all of them, then a state high court using its state constitution can be that laboratory of democracy and experiment with granting greater rights to its citizens. So the language I quote to you from Pompino versus Claridge of Pompano Condo was less than simply taking its own path. But you need to understand that when done correctly, when done without violating any federal rights, a state can take its own path. The contracts clause could have meant, it doesn't, it could have meant something entirely different under Florida's constitution. It matters not that the language might be similar or even identical to the language in the federal constitution, so long as there's an adequate and independent state law basis for the state high court to interpret it that way, then it can have its own body of case law, its own jurisprudence, its own independent meaning. And I don't want you to miss that point. When we look through chapter 4, what we find almost invariably is the ship has not sailed, by which I mean the state high court left the door open, left that crack, left the potential, but didn't embark on a voyage, didn't sail off in its own direction, didn't take an independent interpretation of the particular constitution. And if we look at so many of these rights, freedom from imprisonment for debt, right to work, even right to bear arms, you see within chapter 4 that although the door might be left open, what we don't have is a unique Florida constitutional law jurisprudence. We might have some finite differences, but we don't have a unique jurisprudence. And join me, if you will, on page 169. Join me, if you will, under notes and questions to consider, and join me, if you will, on some of the commentators who opine as to whether these are ships that have not sailed. These are rights that have not developed their own independent state constitutional law jurisprudence. Join me to begin with on page 169 and note 2. Here we're in the Penn State Law Review. This is Lawrence Friedman. He's talking about path dependence and the external constraints on independent state constitutionalism. Path dependence. What he means by this phrase is, much like you saw in that language we quoted for Pompano, states are finding the Supreme Court of the United States may not be binding. Oh, but their opinions are so persuasive. Oh, they're so well written that we'll follow the same path. Path dependence is one of the ways to express a lack of an independent state constitutional law jurisprudence. Look at Professor Friedman's criticisms. The promise of, quote, the new judicial federalism of the independent interpretation by state courts of state constitutional corollaries to the Federal Bill of Rights has gone largely unfulfilled. In terms of doctrinal development, the project of independent state constitutionalism, launched in earnest decades ago with the publication of the United States Supreme Court Justice William Brennan's call to arms in the pages of the Harvard Law Review, is today more an aspiration than a practice. What this commentator is alleging is that most states are path dependent. They're simply taking their constitution as a rephrasing of the state constitution. They're not experimenting with granting greater rights to their citizens. Is this commentator alone? No. Join me on note 3, page 170. Here we have James Gardner. Never met the guy, but I've read so much of his work, I really should. The Failed Discourse of State Constitutionalism is what he calls his 1992 article in the Michigan Law Review. Look at the excerpt I quote for you there. Justice William Brennan wrote an article in which he called upon state courts to step into the breach left by what Justice Brennan perceived to be the U.S. Supreme Court's retreat from its commitment to the protection of individual rights. Brennan urged state Supreme Courts to seize control of the protection of constitutional rights by looking to state constitutions as potentially more generous guarantors of individual rights than the U.S. Constitution. And now, put yourself in the shoes of this researcher that Professor Garner imagines in these pages. Put yourself in these shoes. Imagine that you are researching potential challenges that your client could make to a state law. You research federal constitutional law and find that you have a potential argument under, let's say, the Equal Protection Clause. But you soon find that the standard applied by the federal courts, suppose rational basis review applies, is so differential that your federal claim is a guaranteed loser. Good lawyer that you are, though, you recall that your state constitution also contains an equal protection clause. Perhaps you think to yourself, the state constitution offers more favorable possibilities for your client. Laboratory of democracy, right? You now begin to research state constitutional law. What do you find? One distinct possibility is that the state courts have held that the state provision means exactly the same thing as the federal provision, and that whatever analysis the federal courts use under the federal constitution is the analysis that should be used under the state constitution as well. This result is unsatisfying, but at least it ends your research. After confirming your conclusion, you abandon further state constitutional research as unproductive. It adds nothing to your case. If you mention the state constitution at all, it might be a pro forma citation just to remind the court of the dual nature of your claim. Now suppose that you are luckier and find that the state provision either has never been construed or that the state Supreme Court has held that the meaning of the state constitutional provision is not dependent on the meaning of the federal one. Perhaps you even find a handful of cases in which the state courts have rejected the analogous federal analyses and have reached results different from those that federal courts would reach. Your heart is filled with hope. Although you will not find your argument handed to you on a silver platter, you at least have an opening, it seems, to craft an argument that the state constitutional provision has a meaning more favorable to your client than its federal counterpart. Let me interrupt the story for one moment to make sure you understand where you are now. You've gotten lucky, you're filled with hope, you've read something like the language we just quoted from Pompano, where the state's high court has left the door open, okay? So we're not over here on the spectrum, on the scale, where there is no room for hope, but yet we're not quite over here where the ship has sailed into new waters and vast horizons and found greater rights. We're somewhere in between. We're somewhere in between. And my question to you as a practitioner is, now what do? You're not stuck on this side of the scale with the interpretation in the federal court. Remember, in our hypothetical from Professor Gardner, that was a sure loser. So good thing we're not stuck over there. But we're not exactly over here with fertile fields and new plants and new horizons. So what do you do then? How do you flesh out that argument? How do you make that argument for a greater right for your client? That's where we are in the professor's story. Let's go back to it. Now you get down to serious work. After all, you know how to do constitutional law. You will comb the state decisions to unearth the relevant history of the provision at issue. You will figure out which framers of the state constitution, the Supreme Court considers influential, and you will discover useful tidbits concerning their constitutional philosophy. You will ferret out from state Supreme Court decisions broad language about the history, purpose, structure, and political theory of the state constitution. You will then weave these materials together in a coherent and convincing story about the state constitution, perhaps contrasting it with the familiar stories of the federal constitution. This story will form the basis of your state constitutional claim on behalf of your client. Wow, that's a good goal, right? So how's that going to go when you actually set forth to do that goal? Continue with the story. When you undertake this research, here is what you are likely to find. After reading dozens of state constitutional decisions, you have absolutely no sense of the history of the state constitution. You do not know the identity of the founders, their purposes in creating the Constitution, or the specific events that may have shaped their thinking. You find nothing in the decisions indicating how the various provisions of the document fit together into a coherent whole. And if you do find anything at all, it is a handful of quotations from federal cases discussing the federal Constitution. You are able to form no conception of the character or fundamental values of the people of the state, and no idea how to mount an argument that certain things are more important to the people than others. If you have found state court decisions departing from the federal approach, you have no idea why the courts departed from federal reasoning. At best, you're left with the vague impression that the court simply thought the dissents in analogous federal cases were more persuasive. But nothing in these state opinions gives you any idea of what you, as an advocate, could say to convince the state courts once again to reject the federal approach as a matter of state constitutional law. And the Professor Gardner concludes this excerpt with this conclusion. This story illustrates what I call the poverty of state constitutional discourse, by which I mean the lack of a language in which participants in the legal system can debate the meaning of the state constitution. The poverty of state constitutional law discourse. I shared with you several lectures ago that I was in a room with noted professors whom I respect. Who knows? Maybe they respect me. And they asked me if this class, this very class you're taking, should be a required part of the curriculum. And they looked at me like I was from outer space when I responded to them, no. And why I responded no was because of the poverty of state constitutional law discourse. I regret to inform you that you will note this poverty of state constitutional law discourse as we continue forward in our studies. I have done my best in chapter 5, 6, and 7 to identify, clarify, and classify those instances where Florida's Supreme Court has taken its own path. Sometimes all I can do, like with the Equal Protection Clause, as I told you earlier, is carve out a particular instance where there is a greater right for a particular class of individuals in a particular situation under Florida's Constitution. There are other times, such as when I turn to the law of privacy in Florida's Constitution, where I can, with confidence, identify for you that there is a greater right under Florida's Constitution. But after so doing, I will then struggle and stretch to try to get you the case law that would allow you to do what our hypothetical researcher in Professor Gardner's example was trying to do. And that is to have a clear and coherent, citable, authoritative argument as to what the priorities were of the founding fathers and the drafters of the Constitution, as to what the goals were of those who added this term to our state constitution, and therefore a persuasive argument as to how to interpret and analyze what you find in the state constitution. What we're up against from this point forward, in my opinion, has accurately been described by Professor Gardner as a poverty of state constitutional law discourse, and has accurately been described by Professor Friedman as an independent interpretation that has gone largely unfulfilled. The potential is there, but the hard and fast rules of law that vary significantly and are not path dependent with federal law, more often than not, are not there. So when I discuss with you human rights, Declaration of Rights, civil rights, and those big topics, what I find invariably is that state constitutions, like society in general, avoids these big discussions and has kicked the can down the road from generation after generation without answering these dilemmas. The potential is there. And that's why I began our semester with Chapter 1, with our analysis of Michigan versus Long and an adequate and independent state law basis, so that you could see what a laboratory democracy was intended to be, and that you could see the nuts and bolts as to how to get there. My purposes with Chapter 2 and 3, the canons of construction and the pleading requirements, was to try to help you along the way in the hypothetical story that you just heard from Professor Gardner, as to when that researcher, that litigant, that lawyer had hope. Remember that in the story? And decided they wanted to craft a state constitutional law argument, and were looking for those elements in the case law. That was my goal in Chapter 2 in giving you the canons of construction, to give you those nuts and bolts so that you have something to turn to when you're attempting as a litigant to make an argument under state constitutional law that might not be path dependent with that under the federal law. And that in part was also my goal with Chapter 3, where I tried to show you how our state courts interpret these arguments so that you could accurately put them forth. So now in Chapter 4, for the most part, I identified to you those rights that are path dependent. We're going to finish Chapter 4 next week with those topics that were so near and dear to my heart. Thank you for helping me give them the proper time that they need. And as you turn to the rest of this chapter, invariably you will find yourself in the shoes of that hypothetical lawyer that Professor Gardner was describing to you. But you need not give up hope. First, as we look at Chapter 4 and we see the path dependence, we have for ourselves a mini outline, if you will, of federal constitutional law. It has been my experience that not each and every one of my students, despite having taken federal constitutional law before seeing me, fully grasped and understood each and every nitpicky detail of federal constitutional law. Perhaps this summary of it, if you will, which is what it becomes due to path dependence, might be of assistance to you in better understanding federal constitutional law. More importantly, as you see the path dependence, I try to point out to you where that window is, where you as a litigant might deviate off the federal path and have a basis using your canons of construction to make a state law argument. So please don't see Chapter 4 as a waste. And ultimately, please don't see your state constitution as a waste. Because in Chapters 5 and 6, I will give you that glimmer of hope. And I'll do my best to identify, clarify, and classify those rules of law that have been developed. Some of them you'll find to be better developed than others. I dare say you won't find any of them to be well developed. but I will give you rules of law that you can apply both as a practitioner and as someone who's taking a Florida bar exam. We will also be discussing those areas of the state constitution where the federal constitution has yielded insofar as SCOTUS has found that states have an adequate and independent state law basis to do so. For example, we will study Florida's state court system. We will study the appellate courts, the jurisdiction of the trial courts. We will study extraordinary writs, how to obtain relief from those courts using an extraordinary writ, most of which are different and not path dependent with the federal constitution. We will be looking at sources of law that are neither national nor statewide. We will be looking at laws that arrive from counties, from cities, from towns. Where does their lawmaking authority arise? What can they do? Can they take away my money? Can they take away my freedom? You'll find the answers to both questions are yes. But just like the Florida legislature, you will find that the lawmaking bodies that are sub-state, such as counties, cities, and towns, that they have limits upon their lawmaking. We will discuss lawmaking and its limits. And finally, most promising of all, we will discuss one area of the law where a Floridian certainly has greater rights than Americans as a whole when it comes to open government, government transparency, government in the sunshine, if you will, referred to as Florida's sunshine laws. You will find that a Floridian has greater access to the papers in the possession of state government, greater access to transparency into government, be it a meeting, be it just a committee, be it two elected officials that happen to be discussing public issues, whether in public or in private, whether verbally or through texts or emails. You will find that a Floridian has far greater rights than Americans as a whole to open government from Florida than Americans generally have to open government from the federal United States government. So don't give up hope. But at the same time, don't overestimate your state constitution. These commentators are absolutely correct that there is a poverty of state constitutional law discourse. So with that in mind, we will finish chapter 4 next week by focusing upon those rights akin to those in the First Amendment of the U.S. Constitution. Please read those cases, know them well, be ready to be called on at random, discuss with me what they mean, what they stand for, and whether Florida has taken its own path, and if so, what greater rights does a Floridian have? And once we wrap up that discussion, we will proceed promptly into chapter 5. And most importantly, I'm looking forward to catching up. I've fallen behind on my lead counsel. I look forward to getting to know each and every one of you as you are voluntold to be lead counsel. So we're gonna at least get the names and alma mater of those who served today. Well done, by the way. And last week, well done. All right, well done. And of course, if you're on tap for next week, be ready. Until then, rest up. You all look tired from midterms. You remain in mine and my wife Bernadette's prayers for your success. I'll see you in about a week. Oh,
I said you're not providing protection for me.
Oh, no.
I have a question now. It's about like synthesizing the material. Not like the book is great, but like do you have a supplement that you recommend or anything?
I always dreamed of someone like writing
Right?
a hand out. I even thought like maybe I could reach out and like even buy finance such a project. I really want that to exist.
I felt
I really do.
outline, but I feel like it doesn't really like coincide with the other.
I don't know.
So there's an outline running around out there. The problem is that it's the third revision of this book. So,
I just didn't know if you had
I'm blind.
you know, I really don't, but if you're gonna write that,
Okay.
yeah, I'm really interested.
I'll do my best. I'll do my best. I'm sure there's one out there specific to you. Okay, just haven't found that.
Yeah.
So by interfederalism, it's hard to done that. But question, does this poverty of state discourse more or less render the language of Kelly almost having a tiger, in that it says the foreign court is obligated to give primacy to foreign law that matters that impact.
No, because that remains true, but putting it into practice is where it falls short. You know, that potential is there. I'll see you next week. All these are ships that can sail. Some are ships that haven't sailed. Others are ships that are kind of sunk insofar as we amend the Constitution of the state of Florida. The state must be interpreted the same way as the federal. That's almost like a ship that's sunk, you know? But the potential is there. It's always there. The problem is the potential is where path dependence is the rule, not the exception.
Okay.
So in theory, it's intact, but in practice, not quite in the water, but almost.
You find yourself, like Garner described, you find yourself without the tools. One of the things I really want to do with my writings is to create those tools. Oh, thanks, man. No, that means a lot to me.
No, really, that's interesting.
Thank you. But with that said, when you see potential for improvement, I'd like to hear that too.
Absolutely.
So I want it to be all it can be. It's got a publisher now. First was coming out in November, then December, now it's January. So who knows, maybe we're February. But the Carolina Academic Press picked it up. So their editors are working on it. I hope they're doing more than catching typos, or somebody needs to do that. You know, I hope they got some really good substantive feedback.
You could ask anyone.
You know, the rare few I got rid of, I wish I had. So I'm with you on that.
I mean, the way
I got rid of my UCC book, and I sure wish I had it.
it's always good to have a horn book. You know?
I should take a picture of my library over the wall. I've got hundreds and hundreds of books.
I took a picture and everything.
I have a picture too. Yeah, because I did the same thing. I took a picture before.
I was using my supervisor.
Yeah, and now instead of like a big window, it's just open here. That's
No, but that's, he was on his way.
Forgive my loss with Voltaire.
Oh, loving it, man.
He was
I may not be able to say that. Oh, yeah?
direction of his training is introduced you to
Remember the last two masters that were reviewed?
so I kind of resigned after that. I was like,
I would resign too.
most religious person.
Oh, were you? I was too. Yeah.
I'm just gonna quit. But it was interesting.
You do what you gotta do. Man. Find the groups where you want to be. I'm trying to find my life. Is that my life? Oh, it's here. Here we go. I love it. I love it. So some of these books I carried around from apartment to apartment during law school and after law school. It's so nice to finally keep them at home. In a room. It's so nice.
Okay, you have a wonderful week.
All right, you too. It's good talking to you.
Good talking to you. I'll see you.
Then she did this event.